Hey everybody, it's Greg Siskin here and Jeff Joseph, and we have we're kind of quiet today as far as participants. Chuck's on vacation. I don't know if we're going to have any of our colleagues jump in, so we
There's
will.
on vacation as well.
He's on a deserved vacation. That guy works like he answers. I mean, he must never go to sleep. Anyway, so we'll give the quick update. I just created in honor of Chuck and Lily the banners for each of the cases, and then we'll answer some questions, and then we'll see how this goes. So let's start out with go. On here. So why don't you talk about a little bit about what's going on, Jeff, and go, and some people probably saw some news on Pacer about a related case, and we may want to just kind of put that in perspective on there.
So one of the things that happened was that the government did not respond to one of the pleadings in was it the Jacob case? It was no, it was the Good Luck case. I can't remember whether it was the Jacob case or the Good Luck case. But the response was that one of the legal teams, Curtis Morrison, filed a motion for default judgment, which is essentially a motion arguing that the judge should rule in their favor, which, as you heard from us on previous calls, we would never do because it would never be granted. The government gets all the leeway in the world with these things. And so the judge issued a fairly scathing decision, basically saying, this is a waste of time. You've already taken up a lot of my time with pleadings, and this one is clearly a waste of time. And if you continue to file things like this, I will consider sanctions.
Yeah, I mean, I don't think we need to sort of get into like whether it was a good decision or a bad decision. I think people are just concerned is like, does this have any impact on the other cases? Or should I be worried about what this means for Go or for Acker and Gomez and anything like that? And we talked about it and we decided, that we think that it's pretty unrelated, and this judge is not going to take it out on anybody else, or for that matter, probably on the plaintiffs in that case either. He's seems like not the type of person that would do that. So
I'm not disparaging Curtis in any way. I think Curtis and Raphael are both very, very aggressive lawyers. I think they do a great job. It's just that we'd have a different style. We wouldn't do that.
Yeah. But anyway, I just don't think there's anything to worry about for any of our plaintiffs with respect to that, and probably none for his plaintiffs either on there. But it was making the round, so we figured it was worth mentioning. Jeff, any new? We're just in waiting mode for Judge Maida on our case. We've made our arguments. Could be well, I don't know. Some of the people already lost the bet from last week. As far as the timing goes, we're still waiting. Hopefully we'll get a decision on that pretty soon. Another case that we're in waiting mode on is Kinsley. Mm-hmm. And this is the case that's challenging the visa bans that are tied to the COVID travel bans. And some people keep thinking that the Biden administration is going to moot us out by just dropping all of this. But alas, not to be. Even Canadians, the poor Canadians who opened their doors for Americans to come there, and the U.S. just basically thumbed their nose and said no, nothing in return. But anyway, that case it's been fully briefed. We will probably get a decision in writing. I guess it's up to the judge. He could, request some arguments either in person or on Zoom or audio, but we think it's likely he's going to make an issuance on the rule on the briefs. It shouldn't be that hard for him, given that he's ruled on this issue previously, the exact same issue. But he's just got to get to it. So hopefully we'll get some news on that pretty soon.
Yeah, and to the government's credit, they continue to process cases, which is amazing and great. And so we've seen a lot of movement this week out of Frankfurt, right? Was it Frankfurt, or we saw some out of London?
For Kinsley or for the other cases?
Oh, you're right. That was Kinsley.
Or Milligan.
It might have been Milligan. You're right. I'm sorry.
Because that's the next one that's up. Yeah, so Milligan, we've seen we're still seeing a steady stream of folks getting interviews, mostly round threes, because round two is mostly done. We still have several Manila plaintiffs. We're going to get to the Manila case in a second, the new one, because and this is one, Jeff, when we do the check-in on Milligan, we're getting interviews for Ramirez plaintiffs, but we're still not seeing the same movement with Milligan, which is unexplained. So I think we need to find out why that might be happening.
Yeah, I think I had promised to do that on the last call, to email Joe, and it skipped my mind. So let me write it down. I'll do it after this call.
Yeah, we want to get these. I mean, there's not a lot of you guys left, round two folks, in Milligan, just maybe 20. We don't have round one's done. Round two, we just have that small group, and then round three is whittling down as well. So there have been a couple of Milligan Manila folks that have gotten interviews and seen some movement, but clearly that's still the problem consulate in that case. Mm-hmm. And Ramirez, as we're mentioning, Lily Axelrod just updated us right before the call on that. And in Ramirez and in King, both of those cases, we've seen a steady stream of good news coming for plaintiffs in both of those cases, either interviews being scheduled or people actually getting interviewed and getting here. So that's like a twofer for us between those two cases. Those they seem to be moving. Lou. So
one more note on Lily gave us one more note on.
What was that?
It was about something about people had been getting a notice and that they could ignore it.
Let me see what she said on here. She said Manila. So Manila folks, and she didn't specify whether it's both Milligan and Ramirez or just Ramirez, were receiving a generic email from the State Department reminding them they will continue extending the K petition beyond the standard validity period, and they don't have to do anything to keep the case active. So that's a useful thing to note, that anybody who has a
one question, Greg, we take Manila plaintiffs in round three?
No. Our Milligan Manila plaintiffs are all round two. We only did tribal band people round three. But she didn't specify whether those emails were going to Milligan round two Manila people and Ramirez people, or both. I suspect probably both. But it's the same issue. We've seen this come up in other countries. I know we had people in France that were having this issue, in some other countries where the consulates were telling them they're, even going so far as to actually close some files for people on the grounds that the petition had expired. And we intervened with government counsel and got the problem fixed, but it still seems like they can't seem to get the message out. Some of the consulates that, that's not okay. In this case, it may have been that they're just responding to internet rumors that's happening. Lily didn't say that. I don't think we've had. Well, I may be wrong on that. I don't think we've had people who've actually had their cases closed. But in any case, if you're having an issue with that, or you get some kind of communication indicating that's a problem, reach out and we will let government counsel know. Hopefully it's not happening. I'm going to stick to the K1 cases, and this is Penn for Rio. I don't think we have any news on that one.
No news.
No news on that one. And then Pomerenko is the last of the K1s for Russia. And with that one, Jeff, it seems like the big issue with these folks is getting their cases moved to other consulates.
Yeah.
Have we heard anything back from government counsel regarding that? Because I know we're flagging that for them.
No, we have not heard back. And to be honest with you, I think even the Department of State doesn't really know what the plan is for, Moscow mission and where they're going to send all those cases.
Yeah, they have a few distractions today. Okay. Lou, so this is our case for the multiple H-1B filings and the H-1B lottery. That one, the main thing we're trying to accomplish, and I know Chuck and I think James had a call with all the plaintiffs earlier in the week, but in case you guys missed that, we are trying to get a plaintiff's employer petitioner to join the case as a plaintiff, and we do not intend to charge for that employer that joins on the case.
Or multiple employers.
Or multiple employers, but it sure would be helpful in that case if we had a couple of you guys. So I know that people are at work on that, but if you're just hearing about that issue now, see if you can reach out to your employer and see if they might be interested in helping.
I mean, the argument that the problem there is we don't want standing to be anything that the judge needs to struggle with, right? And it did come up at the TRO hearing. So rather than make it an issue, it's easier just to have a plaintiff, an employer plaintiff.
Right. We just want that to go away. Okay. The EB5 case, this is the same report as for the last, since June 30th. Basically, that case is on ice right now. Because the EB5 program is on ice. We anticipate EB5 will be coming back, and when EB5 when it's possible to issue a visa in an EB5 case, then we will proceed with trying to move that case forward. Humane Society of New York, we don't talk a lot about that on this call, but this is a case we're co-counseling with Ayla on, and this case is about it's similar to the DOL wage rule case that we had last year for Purdue University. In this case, we're challenging the way that the H-1B lottery rule involving wages was rolled out. I'm pretty confident we've got a sort of an ace in the hole winner with the Chad Wolf argument in that one, but we want to cover all our bases. So we are working on getting the next round of pleadings ready to go in that case, and probably would be
should be filed this week. We just need to gather the declarations from the plaintiffs. And
so that's in the works, and that will be happening this week. Let's see, Jacker Barty. I know a lot of people are waiting on that update. So this case is we have been circulating and reviewing the draft preliminary injunction. It was going to be filed tonight, but I think it's going to be tomorrow morning. We've got some really strong arguments that we want to make sure just are clearly delineated in there. And we've been talking also, at least with one very, very reputable lawyer today, about doing an amicus brief for us. But anyway, that's tomorrow, probably that's going. We did file the amended complaint since our last call, adding a number of new plaintiffs. And we also have provided the government a spreadsheet with at least the initial round of folks, receipt numbers and A numbers. We are going to be sending an updated list probably tomorrow, I'm guessing, with the new people that have joined the suit and their information. So hopefully USCIS will do what it seems like they're trying to do, which is to move some of these cases pretty quickly.
And Lily did get notice that one of the Chakrabarty plaintiffs did get an adjustment interview today. They had their adjustment.
Oh, very good.
They got their green card. I don't know. They had one or the other today.
Yeah, we're actually not anticipating interviews for a lot of folks, because one of the things that I think we talked about last week, because I think it was already news last week, is USCIS has officially confirmed that they are routinely waiving on a case-by-case basis the interviews for I-140. So, the big issue, and we talked about it last time as well, is the medicals on there, and I think we're still waiting on some further clarification from USCIS on whether it's possible to interfile medical exams. There are ways to do that, but the I'll give this one piece of advice because it's really not litigation. It's not related litigation, but I'll tell you what we're telling clients. We will interfile the medical, but we're asking people to get 2 envelopes from their doctors that are identical. One we'll send in with the interfiling, and one we will hold back and wait for a request for evidence to come in. And if we get an RFE, we will send the second medical, and that way everybody's covered on there. But that's what I would recommend for our plaintiffs, that if you're in that situation and you want to interfile, I don't see any harm in doing it as long as you have the ability to file a medical instantly if you get a request for evidence that somehow that medical doesn't make it to the file. I don't know if Jeff.
Yeah, I mean, that's the real problem, right? Is that there are hundreds of thousands of files sitting in the centers. And so I have very little confidence that if you file something with a receipt number, that it will actually make it to an adjudicator's desk and be married to the file. So
yeah, I mean, I just don't see any harm
we're telling
doing it. So it's and if you're not, a doctor shouldn't charge you for a second exam just to give you a second copy of it. So if you're paying for the medical exam, and you know, there's really shouldn't be any added expense to doing it that way. But talk to your lawyer. One thing I would tell you is don't interfile without talking to your lawyer on there. It's very frustrating from a perspective of an immigration lawyer when clients file things like that without their knowledge. So make sure you have that conversation, and probably it's better to come from the lawyer. But that's something I do not want to be accused of recommending people do this behind their lawyer's back.
No, and I agree. I mean, we are doing the same thing you're doing, Greg, but the normal process is you get a request for evidence and you submit it with the request for evidence so that you know that it gets married to the file. So, you know, the big question when they announce that medicals are good for 4 years is, okay, but how do we file them, right?
Well, right. So we've seen some lawyers actually that have been doing it prior to this news successfully, and the most interesting one is the generating your own barcode and slapping it and pasting it into the cover letter, and also taping it on or pasting it onto the envelope, and that I think is a very good idea if you want to increase your odds that it will make it to the file. So that's something also to have a conversation with your lawyer about that. Generating a barcode is actually a fairly easy thing. I think people think it's some like voodoo magic on here. They're just this like websites. It's like generate a barcode. If you Google that, it'll take you to about a dozen places that can do that quite easily. I think that's, and what am I forgetting? I'm sure we're going to see it in the comments in a second here. But
that's okay. We can go to the comments, and if they come up, we'll address it.
So let's get going on here. We actually, boy, that was a question that was lined up pretty early for us. 25 minutes before the call started. This is from Malik Hamdi. Can the judge is waiting for voting for? No.
Yeah, I would guess no, because I don't think the judge is going to have that kind of in the weeds knowledge about how KCC functions, or really even what a DQ is. So I don't think you need to worry about that.
It's an interesting question, but I'm pretty sure that Judge Mehta is not doing that. All right, Ahmed Farhad. Being non-documentarily qualified, is that affecting people in the order? In other words, if you're not DQ'd, can you get your visa reserved? I don't think it has. I don't think one has anything to do with the other.
If you recall from the Gomez case, he applied a formula for reserving the visas, and Greg, that formula was what the normal processing was pre-COVID at that time.
Yeah.
So, so that's what he's going to do. He's going to look back to what processing was prior to COVID, and that's the number that is going to be normal.
By the way, I cited the Gomez immigrant visa data from last September somewhere on social media, where somebody was like talking about how 2000 is really a lot of special immigrant visas to be issued for Afghans in the last 2 weeks, and it's like, that's not that hard for them to do. They have the capacity to do a whole lot, and that's a good example of that, where they were able to adjudicate 5,000 visas in roughly 3 weeks last September on there. So hopefully we'll see that big rush after the judge's order, so that we don't have to deal with the reservation. But well, hopefully we'll get a positive order in the first place, and then we'll see on that. All right, I think we just addressed this issue. Let's keep going. Cairo, 808 tourist visas in June, while only 2 DVs. Yep.
Yeah, the good news about Cairo, Ahmed, is that they're cooperating in our case, right? That they've been really good in our case that we filed.
Well, in the K1.
Yeah, in the K1
case, not in the DVs though, apparently. So they have well, Egypt is a strange consulate. They really, I don't think they have their act together at all. Okay. I've sent documents to KCC. You got auto reply. Could you please suggest if you resend the documents now, or it's redundant? I think once you've sent them, I mean, as long as you know that they got there, there's no point in resending.
I agree.
Okay. Who's Morgan Miles?
I don't know.
Okay.
And if UOS stopped reviewing documents, I guarantee our association would know about it.
Yeah.
So I don't think that's true.
Okay. Hey there, Manila folks. Continuing on here. Do we think there's a chance that Judge Mato will raise the priority for DV visas for September? I don't think the order will give them is going to talk about priorities. They're just going to say, do it.
Yeah.
And they're going to have
we didn't ask for, we didn't really challenge the prioritization of DV. I mean, directly, we said it's arbitrary that they're down at the bottom, but we didn't really challenge the prioritization scheme. So I don't think he's going to change the priority. He's just going to say, essentially, look, you've got an obligation to do that. If we win, he's going to say you have an obligation to do this before the end of the fiscal year. You need to do it in good faith. And here's what I think good faith means.
Right. I mean, we could see if he does a reservation of visas, then I can see that issue coming up at that point.
Right.
Where they're just saying, well, we're reserving the numbers, but we're just treating it as a low priority on there, in which case we might have to go back to the judge, but it's sort of like one step at a time. Let's just, let's get the visas reserved, and then we'll deal with that issue if it looks like they're dragging their feet. Okay, what's the date the government needs to respond for the London K1 case? Do you have Pacer up?
Yeah, I can pull it up. Just keep taking the questions and I'll look it up.
All right, we're coming back to that, Charlotte. Okay. In Chakrabarty, USCIS is saying they will be approving the highest number of current cards. Yeah, I saw that. Does this include 2005? Looks like they're getting some good press due to that. So I think 2005, if I recall, Jeff, was the year that they had the recapture of nurses. So they had more numbers than usual that year because they had 50,000 extras. So my guess is what they're saying is that they are not is that they are just saying that they, in the last 16 years they will not have issued this number. Frankly, it's like I'm not sure what they haven't released data at this point to convince me we're even going to meet last year's numbers, much less exceed or go for a multi-year high. On the other hand, well, that's based on data that based on the anecdotal data we've heard already. They do seem like we're starting to see a pickup in interviews, and some of these recent policy announcements look like they're trying to clear the way to be able to approve a lot more cases in these last 6 weeks, so 7 weeks, 6 weeks, I guess. So I don't know. It's just a guessing game to figure on that out. And we, look, it would be great if our case leads to this big surge in approvals, and most people get their cases approved. But we're not holding our breath on that. Okay. Is the new plaintiff's details sent to the government attorney?
Yeah, yes, it has been.
Well,
Not from the amended.
the amended complaint was filed with everybody's name, so everybody is in the case.
Mm-hmm.
The receipt numbers and A numbers. Lily actually had a message for us on that too. She said, we've received updates and A numbers from almost all plaintiffs. Gracie from our office has been in touch with those who are still missing. Check your spam, junk mail if you didn't get a link to give us that updated information. And I think that the plan is tomorrow to send that. But if you don't get us the information back, you're hurting yourselves, and we're not gonna delay our other plaintiffs or hurt them by waiting any longer. But you basically have till tomorrow in the AM if you want to be on that list, which you do want to be on that list if you're a plaintiff in that case. That's why you're suing. Okay. Has K1 London King versus signed to a judge yet? Right, did you manage to pull up King?
Yes, I did. So King is due on September 14th is their government response date.
Who's our judge?
Let me look that up. I closed out a pacer, but I'll get back in.
I'm pretty sure we do have a judge.
Yeah. Where would I like to go? DC.
All right, I will keep going. Okay. Father wants to file adjustment under EB2 category. I'm not sure what this has to do with the cases, but this is a litigation call. If you're wanting to talk about case-specific questions, you might tune into my Facebook tomorrow, which will be at 1 Central Time.
It has been assigned to Judge Paul Friedman. Paul Friedman.
Right.
He's a new one for us.
Yeah. We'll see how Judge Friedman is. Okay. So we just talked about that. Okay. Okay. You email the consulate that and KCC simultaneously to schedule, and they say they're waiting on KCC, but KCC refuses to schedule, and Morgan Miles states Post can request ad hoc cases to schedule. What else can I do? All right, so I want to make sure I understood this. You email the consulate and you CC the KCC, and the consulate just replied saying they're waiting on KCC, and KCC refuses to schedule. So I mean, I guess that this is interesting. Ultimately, I think the consulates are usually more to blame than KCC, because I think KCC just basically holds until the consulates request request the information on there. And so when they say that they're waiting on KCC, I think almost all the time the consulate's just pushing, just not being completely forthright with you is, I guess, the generous way to say it on there. I would just keep nagging them at this point. I'm not sure. I guess what is this mysterious Morgan Miles? I'm not sure if that's he's saying that, see about getting into like canceled appointments or when slots open up. And that's always like a thing. We saw that like with our London folks. London does that fairly regularly, where people will get notified that they are going to we have a slot available in 2 days. If you can make it, that kind of thing. And you can, I guess you can email the consulate and tell them that you're available for that. But I'm not sure that there's a procedure for getting on any kind of list or, for that. I don't know how, and I'm guessing it's also specific to the particular consulate. But of course, they have to have your file from the KCC in order to be able to even do that. So that's the best thing I can think of to tell you. Patrick, thank you. Always nice to hear nice comments. All right. Okay. Well, that would explain why some of the Ramirez people are hearing prior to some of the Milligan people. Would be just the case numbers are older on there. Um, I need to check in with Lily and see if she has done any kind of deep dive into that as far as like the dates of filing, comparing them to Milligan. But I think actually what would be probably helpful for us, Jeff, and I'll talk to Lily about this, is doing a spreadsheet where
Yeah, that would be great.
we can look at I-129F approval dates and see how they compare. Okay. After sharing a number, when can we expect USCIS to start processing cases and getting updates? So what I can tell you on that, I don't know if Jeff, I have a feeling Jeff will be the same thing, is that all we know is what that very brief communication we had from them saying that they want to try and adjudicate cases, and that's why they were asking to pull these files on there. And they haven't told us anything more than that, so we can't give you more specific information than that. But my assumption is that as soon as they pull these cases, that that the intention is to get them work before the end of the year. So my guess is that you probably will start hearing something fairly soon for all the people that we've given the information to them, and then the next group will be after tomorrow. So we'll start to see. Very good, Elliot. Good to hear.
I mean, not good that it takes 5 months, but at least you've got some.
No, but you've got like some movement.
Yeah, for sure. We did not request a preliminary injunction. What you request in a preliminary injunction is sort of temporary relief while you're waiting for final relief. And in this case, we just went straight for summary judgment. And the reason for that is because it's much harder to win a preliminary injunction. You have to not only show that you're going to win the case, but that there will be irreparable harm if it's not granted. And so it's a much higher standard. Summary judgment, you just have to show that you win based on the evidence. So that's what we did. There's no disadvantage. Even if we'd file a PI, we'd probably still be waiting for a decision on that as well. So we're just waiting for the final decision on the case.
Okay. All right, next one I'm going to skip because we've answered. The ruling comes in our favor. Will the visa numbers be reserved even if medicals were not submitted, or to reserve visa numbers? So that won't matter. If they reserve numbers, then it won't matter that the medicals weren't submitted. On there, I don't see
the alternate relief we're asking for, if they don't reserve numbers, is that they consider a number used based on the filing rather than the adjudication. So if that's the case, then you may, then at that point, you would need to submit a medical to show that you qualify for the 485. But I wouldn't do that until we get to that point, right? We'll wait and see what the procedures will be once we find out what the ruling is.
Yeah. All right, it's just somebody, Miho, noting that somebody got an interview from the Go case scheduled for next week in Amsterdam, so that's good news. We've been seeing a steady a steady stream of Go plaintiffs that are actually getting adjudicated, which is obviously our goal, is not just to win these cases, but to sort of win these cases in the interim by getting the getting plaintiffs' cases adjudicated even before we get a judge to make a decision. Okay. K1, I'm pushing 700 days since filing the K. How often do you suggest I contact the embassy to keep my case in good standing? I would say every couple of weeks.
Yeah, that's what I was going to say too, every 2 weeks as well. I wouldn't do it every week because you get annoying, right? And then if it's between scheduling you versus another plaintiff or someone else, they may schedule the other one. So I definitely wouldn't be annoying. I think every 2 weeks is fine. Listen, here's the truth. What we know is absent an expedite, emailing has not resulted in a single interview from any of our plaintiffs in any of our cases, right? Absent having some emergency or expedite, merely emailing is not getting us anywhere. It keeps you on the radar screen for sure. But the only thing that's getting us there is a phone call from the U.S. attorney to the consulate or an order from the judge. So, yeah, keep calling, but don't make yourself a nuisance is what I would say.
Okay. I'm not sure what this what this is asking. Where do we enter files? Seems like my FO is offloading cases to other offices.
Field office. Maybe.
Oh, field office. Well, I think you go where the receipt address is, and keep your fingers crossed that they haven't moved the case since you got.
I mean, if your case is at the field office, right? Or if it's been sent from the field office somewhere else, then that means that they're at the final stages, right? If it's at the field office, they're doing those biometrics changes, and so I would wait for an RFE. I think you're likely to get an RFE if it's that far that far along.
Okay. What's the current status of DV 2021?
It exists.
Okay.
That's about it. It's that's why we're suing.
USCIS saying they will be approving the all right, we've already seen that question. Okay, is there a 60-day limit on doctor's signature and your postmark date to USCIS? Yeah, it can't be more than 60 days before you actually submit it.
Right.
It has to be in that 60-day window. And then it's valid for 4 years, I guess, based on the new determination. All right, answered that one already. I'm just going down the list. I don't know if Jeff, you're looking at it as well.
I am
on here.
Oh, here it is. Morgan Miles is the KCC director that gave a declaration on the updates of KCC.
Okay. All right. Well, that's why we haven't heard. why we were thinking he was an immigration lawyer. Right. That's why no one has ever heard of an immigration lawyer named Morgan Miles. Okay. Thank you. Do federal judges delegate some of their work to? Yes, they do have their clerks do a lot of the work in these cases. And it's a very prestigious thing to get a clerkship with a federal judge on there. So they're usually very, very, very bright, recent law school graduates that are working in those jobs. The judge is not going everything that's going to be in that decision. While a clerk may do a lot of initial drafting, they are reflecting what the judge wants. It's not like the clerk is actually deciding what the decision is going to be, but they can help craft and they're having very close discussions with the judges about how they want the draft to go. But I think that's probably all I can tell you on that. Okay. Not yet. We are actually that is on my to-do list this week is to do we'll either do an after pattern form or a Google form to kind of break down the different kinds of harms and the different kinds of EAD cases. Don't advertise this as an H4 EAD case. This is what we're talking about because there are H4 EAD cases. This is a 765 delay case that affects a lot more people. And I think there's a tendency on the part of a lot of people in the Indian community in particular, because they're the ones that use the H4 EADs, to think that everything revolves around that, their issues. But the Chakrabarty people know that they waited a whole long, time to get EADs issued in their adjustment cases, and students that are seeking OPT wait a whole long time on their I-765. So it's a much broader group, and when we're talking about 765s. So if you come back to me and say H4 EAD premium processing, I'll tell you to contact Jonathan Watson. That's what they're litigating. We're looking at a broader group and somewhat different issues. Okay.
We're not adding more plaintiffs to EB adjustment case because we're too far along. I mean, we're too close to September to.
Yeah, no, we're done. We had one freebie in that, and we just used it. that was one of our lifelines on there. So we just used that, and we wanted to get that filed before the preliminary injunction. The preliminary injunction will be going out within the 24 hours, probably in the morning. It's pretty much, I mean, that document is pretty drafted. Will you comment on
this is a great question.
Okay. So, all right. So that shouldn't matter as long as but it does raise a sort of a question. Since our last call, we did have the September visa bulletin come out. And it is interesting in that bulletin. So they have moved the dates in the final action dates close, but not all the way to the filing date charts that we saw last fall on there. So there are some people who have adjustments filed who will not have a current priority date before the end of the fiscal year. They will not have the State Department is saying that their final action date is not available. So for that group, you guys will still benefit from you're not going to get your case adjudicated by the end of the month. But you will still, we still have this case that's going to be going on after September 30th for unreasonable delay. There will be a new allotment of numbers, and there will be an advancement of numbers. So I'm pretty confident that final action dates for anybody who is in that little grouping of a few months at the end of 2014 that are not current, that we still will be able to keep you'll still be able to benefit from the case. You're just not going to get your visa issued by September 30th at this point on there. As Jeff, I don't know if you want to answer sort of the question here about the improved I-140 part.
Well, obviously, in order to adjust, you have to have an immigrant visa, right? So if you don't have an approved I-140, you can't adjust. That being said, if you filed it as a one-step, they will adjudicate them at the same time. If the 485 is, if the adjustment is available, the visa is available, they'll adjudicate them at the same time. One of
the questions is if you did a downgrade and you already had but I mean, I guess the question is you would have filed the adjustment with the downgrade, so it is a one-step for those cases. So I think that's right, that they would. My guess is that they will probably not put you in a different line if you're in that situation. They'll just treat it as one additional thing that has to happen in the case.
If you have a lawyer, I would suggest you talk to your lawyer about the impact of upgrading to premium processing. There are certain circumstances. So premium processing is available for labor certification based EB2s and EB3s. Well, all the EB3s are labor certification based, but for EB2, that's not going to work if you have, for example, a national interest waiver as the basis for your filing or some other category that's not available for premium processing. But the vast majority of our plaintiffs, I think, have the ability to premium process that I-140, and I think that's a very good suggestion to bring up with your lawyer. Yeah, I would talk to your lawyer, because there may be reasons why your lawyer is choosing not to premium process. They want the I-140 alive and not adjudicated. But, for purposes of portability and other things that are good for you, you'd want that I-140 approved.
Okay. Okay, I'm looking for some new subjects. Any plausible reason for attorney asking for plaintiff details? Any precedent? Yeah, they've done this on some of our other cases where they've wanted more information so that their goal is to get this stuff off their plate as well. So to the extent that they can get plaintiffs' case mooted out by their cases being adjudicated, they're incentivized in a lot of cases to do that. So I think it's not unusual at all for this kind of case even on individual unreasonable delay cases. In a lot of cases, they're working trying to get these cases adjudicated so they don't have to actually go to the judge, and then where it's a much smaller number when they do get to the judge, or they could tell the judge that, they've already made a lot of progress on here and present the judge with the numbers. So I think it's good. It's not a sort of any shocking development or anything like that, but it's certainly a good one. Anything to add to that, Jeff?
No, I think that's good advice.
Okay. Do we get a confirmation after submitting the A numbers? No, we don't
get any confirmation from the government at all. So if we reach out on your case, individually or otherwise, they never tell us what they're going to do.
Honestly, we find out from you guys, whether, when we, a lot of cases, if we, like in Milligan, there were a bunch of them where we brought individually because there was a medical issue or something like that, and some of the other cases as well. And even in those cases, we were just talking about one person. A lot of times we still only find out from the plaintiff that something happened. So it's kind of be nice if they would just tell us what's going to happen when we give them the information rather than having to find out about it secondhand. But that's how it oftentimes happens. Any questions you see there, Jeff, that you want to?
Yeah, this is a good one. I don't know that I'm
going to. Which person is it?
Go to Sahar Atia about the Child Status Protection Act.
This one?
Yeah.
Okay. All right. So a derivative past 21 in that regard. So the derivative was less than 21 when the principal applicant applied. Then they probably still has child protection. So it locks in. So this was an interesting issue for some of our plaintiffs. It was actually helping them by the adjustment application pending for a while. But maybe you can talk a little bit about sort of like when we were trying to figure out, because we did add a couple of people in the amended complaint that we sought out that had Child Status Protection Act issues for the case, because it's a harm that I think is going to be gives us some powerful arguments on that. But I don't know what you're.
Yeah. So the way that the Child Status Protection Act works is that it locks in a minor child's age at the time that you file the immigrant visa petition, the I-130 or the I-140. So their age is locked in, and they don't age for the entire time that the I-140 remains pending. And then when the I-140 is approved, they begin to age again, right? So you subtract from their age the entire time that the I-140 is pending, but that's it. So if the I-140 has only been pending for 6 months, you only get to subtract 6 months, right? That's why I said to the previous person that they should check with their lawyer, because it may be that you don't want to approve an I-140 because it could affect your child under Child Status Protection Act, right? Because
unless the adjustment approval is imminent, and you're kind of rolling the dice that we're optimistic and we're hopeful, but if we don't win, it could be to your disadvantage that I-140 gets approved. So,
so you're correct. The CSPA may benefit you, right? But you have to go through this complicated calculation to determine what your age is.
Or you could build an app, which we have. I'll share that with you, Jeff.
And then the second part of it is that you have to seek your adjustment within 1 year of the time the visa becomes current, which shouldn't be a problem for you if you already have a pending 485. So.
Okay. All right. You live in Doha. You changed embassies. You're worried about Afghans being transferred to that base, and so that's a. The only thing is that with the Afghans, it's not a big number that I think, special immigrant visa applicants that we're talking about. Although, it sounds like they're making a whole lot of decisions on like who's actually going to be included in that. There's just a lot of unknowns right now with Afghans. And, I guess the president right before we came on, he gave remarks and indicated that, well, I heard two things. One is that the spokesman for the Taliban, which they have there's a guy, he was being interviewed on NBC, and he said, everybody that wants to leave can leave on there. We're not going to prevent anybody, and we're not going to harm anybody. So it's like, if you believe him, then it may then it may not be as much of a massive rush. And Biden said they're sending in 6,000 troops with the sole mission to help people leave. My guess is that they haven't figured it out yet exactly where they're sending. I know a bunch of them are going to Fort Lee in Virginia. I don't know how many are going to Doha. We just don't know yet. It's a legit question if you're dealing with processing in a place that all of a sudden is going to have a ton of Afghans there. But I don't have enough information to be able to say anything more on that. Jeff, I don't know if you do.
Well, I just would confirm that Bishkek processes immigrant visas. That's really important. So
yeah,
not all consulates process immigrant visas.
For adjustment cases, is USCIS required to receive the medicals? Yes, that is they can't finish your case without a medical exam. So that is going to be interesting how they match all them up. Hopefully they've got their act together. I can promise you no cases will be adjudicated on September 31st. No, I'm just being mean. There's no that the last day of September is September 30th. But what is a guarantee they'll adjudicate plaintiffs' cases? There's no guarantee. If the judge orders them to do it and then they don't get it done by that day, we will go back to the judge. But the odds are that he'll have a reservation. But if the judge only issues an order to adjudicate everybody by September 30th and doesn't reserve numbers, Jeff, I don't know what happens.
I think that's what we do. We go back to court and say you're in violation of the court's order.
Well, we kind of had that happen in Ocker, where we went back to the judge right before to say they were not going to meet the deadline, and that's when he issued the reservation of 9,000. So that was not in the initial order. So that could be how it goes. In this case, no, we don't have any kind of reply yet from the government.
No. So is this for the EB? Yeah. So the plan on this is we are in the final stages of the PI. I'm going to finish where we have to add in the argument about reserving visas tonight, and then it's ready to go. We're going to send it to the U.S. attorney in the morning, along with the amended chart with all the amended plaintiffs. So that will happen tomorrow. And then the other part of it is we have to confirm.
Why don't you tell people why we do that? Because it is interesting that we basically, before we file, we kind of give them a courtesy of sending it to them. And I think that would surprise some people. Like, why don't we just file it? Why do we send it to the government first?
Yeah. So a lot of motions that you file, and you have to look at the local court rules, but you are actually required to confer with the government. You're not required to send them the complaint.
But what does confer mean?
Confer means you basically have to get their position on your motion. You have to meet with them and get their position, right? So on a simple motion, you may confer with them and they say, yeah, we don't object. On a PI, they're not gonna just.
No, they're gonna clearly object. So on there, so it's a formality, but we have to do it.
Yeah, and so the reason we send the complaint in this, or the PI in this case, is because we have to. They can't say their position on it without seeing it, so we sort of have to.
All right, I'm skipping to this question.
Oh, sushi's great. I haven't seen.
Where's sushi? You're in the wrong room today.
I know, this is my home base, but I have sushi. I haven't seen sushi in 4 days because I dropped my son off at Elon, his junior year at Elon College.
Okay.
So,
all right. Sorry. Tell me they only have capacity for Swiss people with working permits, but you are a Swiss citizen, and why are you not contacting? I'm not sure I understand the question.
I think what she's saying is Switzerland is telling her that they are processing people, but she doesn't understand why she hasn't been processed and why they're not.
Oh, wow.
ACC.
Yeah.
We don't know either. All you can do is keep emailing, right?
All right, I just skipped a bunch. How many plaintiffs are left in go? I don't know. I think still the vast majority of them are still in. I mean, have not been adjudicated yet.
I think I've only heard, Lily probably knows better, but I've only heard of 3 or 4 actual people have been approved.
I mean, we've seen a bunch of people get appointments.
Yeah.
And until they actually get the visa, we don't consider their case. We consider that their status to be exactly the same. I mean, it's good, but we've also seen instances where our plaintiffs have gotten appointments and then the appointments were canceled. So that they don't count. It doesn't count until the visa is issued. Okay. What new file are they talking about? Go.
It's probably, I can look it up. It might be the, it's probably just the summary judgment motion.
Yeah,
motion for leave to reply. Oh, that's what it was. It was, so at the oral, was it the oral argument? No, it wasn't. It was in the briefs. I'm sorry, I get all these cases mixed up because we have so many of them. But in the briefs, the government raised an issue of standing, and we felt like it was enough of an argument. They filed a supplement to their original position on standing. When you file a supplement, you're not supposed to make a legal argument. You're only supposed to alert the court to new authority. But it was our position that they made argument enough in that supplement that we needed to respond. Right. So that's what we did. We filed a 3-page response to their position on standing.
Okay. So in the Chakrabarty case, we actually had our judge change on us. This is in Maryland, which we don't file. I think this is the first one we filed as ImmPact Litigation in Maryland, but we are suing USCIS. We usually sue the State Department, so we're usually filing in the DC district. When we sue the State Department, in this case, USCIS is actually in Maryland, and that's why we sued them there. But the original judge was a Judge Blake, I think. Anyway, she was a fairly senior judge, and the case was transferred, but it's transferred to also a very senior judge. I think a Clinton nominee on there. He's like about in his 70s or 80s on there. Judge seems fair. I think we're fairly, look, honestly, if the case is a good case, it's a rare instance where we would like be upset like by which judge was, Judge Hannon in Texas is it maybe a different story, but for the most part, we don't usually care who the appointments are, who appointed them. We'll look to see if they have a history on immigration decisions. There's not going to be as much with the Maryland judge as a DC district, but the stuff we did see looked pretty good on there. And we think we have a good case. So hopefully we have an engaged judge and we have, somebody who's ready for some action on there. But certainly I don't have anything more specific than that. You got to be careful anyway what you say on social media about a judge on there. But like I said, for the most part, we're usually pretty laid back as far as when we get the news on this, because we believe in the case. It shouldn't matter all that much. All right, Jeff, it is 6 p.m. and I'm going to let you decide what our last question is going to be.
Oh, let's get a good one. Let's see. It looks like Lily actually answered a lot of the late ones.
Thank you, Lily. I thought you weren't going to be able to make it. I guess you made the tail end.
It looks like actually Lily got everything. All
right. Then we will bid you goodbye until next week. Jeff, when is your next time on
we are Thursday at 12 o'clock Denver time, 2 o'clock Eastern.
What's your medium?
Joseph and immigrant attorney. Oh, I'm sorry, Facebook. It's Facebook. Sorry.
Okay, so search Jeff Ad on Facebook, and if you want to watch ours tomorrow, just facebook.com/sisconcessor at 1 p.m. Central. I don't know who will be with me. it may just be me, or we'll see who I can drag on.
I've got Ryland and Jennifer so far.
Oh, good. Good. Okay. Well, next week, Chuck ought to be back, so it'll be a little more entertaining. But until then, see you next time.
Peace out, everybody. Thanks.